34. Politician. The mandatory jail sentences that have become law 2 years ago for certain crimes have enhanced the integrity of our system of justice. For no longer are there two kinds of justice, the kind dispensed by lenient judges and the kind dispensed by severe ones. So the politician is saying, hey, there are these mandatory sentences that became law recently. Mandatory means required, right? Required sentences. And so, therefore, specific crimes, right? So maybe if you commit theft, automatically you get 2 years in jail, no matter what kind of theft it is. Or maybe if you attack someone or there's violence, you get a certain amount of time in jail. And the politician's saying, well, this means that, we're not having different types of justice for based on, how lenient the judge is, so it's more fair, right? It's now based on, what is your crime? This is how much time you get. It's no longer based on whether how the judge feels that day or whether the judge is kind or not. Public advocate. But with the judges stripped of discretionary powers, so that means discretionary means whether they can choose or not. So when the judges really can't choose, there can be no leniency even when it would be appropriate. So even when they should be considerate of someone's situation, they can't be. So juries now sometimes acquit a given defendant solely because the jurors feel that the mandatory sentence would be too harsh. So now juries sometimes just let people go because they think that the mandatory sentence would be too much. Those juries then do not return an accurate verdict on the defendant's guilt. So the public advocate is saying, well, this means that they weren't accurate about whether or not they thought the defendant was guilty. They just let them go, maybe because they didn't want them to have this really harsh mandatory sentence that they maybe didn't deserve, or they felt that they didn't deserve it. This is why it is imperative that the legislation instituting mandatory jail sentences be repealed. So the public advocate is saying, okay, we shouldn't have this legislation. We should repeal it for the reasons that he just said or she just said. The public advocate responds to the politician's argument by doing which one of the following. So we're looking at the public advocate's argument, and we're seeing how they responded to the politician. A, trying to show that the politician's conclusion merely paraphrases the politician's evidence. Okay, the wording for A is describing circular reasoning, and that is when you use something in the evidence, and that's the same thing that you're trying to prove. So if you state what you're trying to prove already as a part of your evidence and you just assume it as true and then say that you've proven it as true, that's bad logic, right? So that's a common flaw. But is that something that the public advocate is saying that the politician is doing? Not really, right? The public advocate never said, well, you used as your evidence what you were already trying to prove. He didn't really do that, right? Or she didn't really do that. That wasn't part of the argument. So it's not A. B, claiming that the politician's evidence properly analyzed has no bearing on the conclusion the politician derives from it. Okay, so no bearing means it has no relationship to it, right? Or it has no impact. So does the public advocate say to the politician, what you said has no impact? So his premises, right, his evidence were that there can't be two kinds of justice anymore, right? Is the public advocate saying, well, that doesn't impact mandatory jail sentences at all, or that has no relationship with mandatory jail sentences? I don't think that's what the public advocate is saying, right? What the politician said, the premises and the conclusion, the evidence and the conclusion, it's all related. The public advocate is just arguing, he's not arguing that they're not related to each other, the politician's evidence and conclusion. He's just saying, well, you're not looking at it the right way. What if, this other situation's happening, right? So I don't think it's B either. Let's look at C. Arguing that leniency is not a trait of individuals, but that rather it is a property of certain kinds of decisions. Okay, so is the public advocate arguing that leniency is one thing but not another thing? I don't think so. I don't think the public advocate is arguing about the definition of leniency, right, and what it is. He or she just mentions leniency as they're talking about this. So I don't think it's C either. D, arguing that an analysis of the consequences of certain legislation undermines the politician's conclusion. Okay, I like D because D is just saying, hey, the public advocate is arguing that when you look at the consequences of this law, right, that it undermines the politician's conclusion. What is the politician's conclusion? The politician's conclusion is that this law has enhanced the integrity of our justice system, right? And so if it enhanced integrity, then people shouldn't be given inaccurate verdicts, right? People shouldn't be let go when maybe they actually should have gotten a charge. And so the integrity is kind of undermined, right? If what the public advocate is saying is true. And that's what D is expressing. So D seems like a good answer choice, but let's also check out E, charging that the politician exaggerated the severity of a problem in order to justify a sweeping solution. Okay, does the public advocate anywhere accuse the politician of exaggerating? I don't think so, right? Public advocate is kind of just saying, hey, look at this other thing that you missed. Have you considered this, right? I think this goes against your conclusion, is basically what the public advocate is saying. I don't think there was any claim that the politician exaggerated in any way, right? Nothing in the public advocate's words suggests that. So we can also cross out E, and D would be our answer.